Good afternoon, everyone. I hope you can hear me and that I'm coming through loud and clear. This is the first of our seminars, online seminars on protecting your cash and an appropriate IP strategy for designs that I'm going to speak on and trademarks that Nicola is going to speak on during this COVID-19 crisis. So, in terms of just posing of questions, there is a chat box or a question box where you can post questions. Any questions you've got of me, I'm going to answer them at the end of my session. And then any questions that you have of Nicola, you can put them to her at the end of her session. Without further ado, I'm going to move on to my slides. So there we go. So cost savings tips, I'm going to outline during the next 10 minutes or so for design applications. So design applications are pretty straightforward in Australia. Essentially, if you file, it will register. It's a relatively inexpensive IP right, but where the costs start to rack up is if you're thinking of overseas protection. And so it's good to have some strategies in place. If you are thinking about a product that potentially has a global market, then it's good to have some strategies in terms of deferring as best you can those costs. So I'm going to outline sort of three broad areas where you can look at this. Firstly, just simply delaying filing your design application, but I'm going to talk you through how late in the process you can delay that filing. Filing what we call a flawed design application. This is a good way of buying yourself a bit of time to make some decisions before you actually then launch, and the option of withdrawing and refiling applications as well. So in terms of the first point, delay filing your design application, we would generally give this advice anyway to our clients, and that is hold off on the design filing until your final form of design has been settled. We wouldn't necessarily give this advice to a patent client or a trademark client, but with designs, because they're quite a specific form of protection and because they really are related to the particular appearance, the recommendation is to wait until you really are sure of the final form of your design before you file it. And you can file as late as the actual launch date. So if you're launching on a particular day, you can file the design application on that day and you'll have your protection from that date. So we would, in any case, normally recommend holding off on filing your design application up until that point. The one overrider there is, as long as you've made sure that your dealings in the design have been kept reasonably confidential between you and the design team or the designers if they're external designers, and there hasn't been any previewing or pre-showing to customers. So that's a simple way of just delaying the filing costs. As I say, the filing costs aren't horrendous in Australia, you know, around that sort of $1,000 to $1,500 mark, but that's including attorney charges, but they do rack up if you start to look at overseas protection. So essentially what you're doing is deferring the whole procedure for overseas protection for as long as you possibly can. The other option is to, and this is a much more risky option, but that is to make use of the grace period. Now, the grace period doesn't apply for all countries. I've given you a list of some major countries or jurisdictions that do offer a grace period, and typically those grace periods vary between 6 months and 12 months. So, for example, in the US, Europe, and Canada, and the UK, it's a 12-month grace period. Japan is a 6-month grace period. Russia is also a 12-month grace period. Australia is updating its legislation, thank goodness. So from sometime next year, we expect there'll be a 12-month grace period In other words, you can launch your design and then file your design application within 12 months. But remember, you're wanting to avail that grace period for each country or market. So you still need to get your timings right. But nevertheless, this is a way that you can potentially buy yourself up to another year's worth of time before you have to incur the filing costs and examination costs in various jurisdictions. The other thing to bear in mind is you can, in terms of delaying a design application, you can withdraw your design application at certain points and then refile it. And particularly, this is the case if your design changes. Now, I'm going to expand on this in the next couple of slides. But in any case, that's the simplest way is to delay filing a design application. One final point just to add there is that in Australia, the examination system is an optional system. So you can file your design, get it registered and not request examination as a way of avoiding additional costs as well. So in terms of this flawed design application, this is a robust methodology. This is nothing dodgy that I'm speaking about here. We do this all the time. We particularly do this for overseas design companies that want their design to publish as late as possible. They don't want it to publish before their product is launched. Car companies in particular are very paranoid about this. So they ask us to try and prevent early publication. The reason why this is an issue in Australia is that after you file, a design registers in around 3 to 4 weeks. So it's quite quick. And at that point it publishes. So your competitors can see, the designs that you've been working on. So what we do is we deliberately introduce a flaw into the application, and the safest and best flaw is to omit the designers' names. So in that field for the designers' names, we simply put "to be advised." And what happens is this provokes a formalities report from the designs office, and you get 2 months to respond to that formalities report. So from the time you file the application until the time you have to deal with that formalities report is about a 4-month delay. And often that's enough for our clients, that 4-month delay. So you can, as I say, you buy yourself 4 months of time. But how can you use this as an Australian company? Well, it's probably not a bad idea for many applicants anyway to make use of this, because it gives you the option to delay taking action around your design application during that 4-month period. If you didn't introduce such a flaw, and if the design did go through to registration and publication in the 3 to 4 week period, then you're really locked into that timetable of getting your overseas filings made. So by introducing this flaw into the application and buying yourself the 4 months, immediately prior, you know what that date is, that 4-month point. So immediately prior to that date, you can consider, do I simply withdraw this application and then refile it to start the clock again, or do I push forward? And again, if you do push forward, take it through to registration, and then it gets published, you can then make a choice as to whether you do file a convention application. So file your 6-month overseas applications from your original Australian filing, or again, as I was alluding to previously, you make use of the grace period. In either case, you've bought yourself additional time to before you have to make the sort of serious decisions in terms of cash outlays for overseas filings. And just finally, this option of withdrawing and refiling. So we do use this from time to time, and I'll just give you a couple of scenarios in which we use this. So as I mentioned previously, we filed this flawed application, we get our 4-month publication delay, and then as we're approaching this 4-month point, it's a good time to sit down and make a review. And we actually sit down with the client and we say, well, has your design changed? Is it identical to what you filed? You'd be surprised how often little tweaks and adjustments have been made after filing, and that may be an opportunity at that point to withdraw the existing application and then refile with the new and latest and up-to-date representations. So that's not a bad practice anyway. You start the clock again, but you're actually protecting what it is you're about to commercially release. Or do you do one of two things? Do you simply not respond to the formalities report and allow the application to lapse, and if you do so it won't publish? Or do you positively withdraw it and then refile the existing design and start the clock again? So all this is a good way of, as I say, buying yourself time, but the overrider in all of these situations is to be careful and make sure that there hasn't been any inadvertent disclosure to third parties, which is of a non-confidential nature. So assuming that you've kept a reasonably tight rein over all of this, then these are a few mechanisms and a few tips that we've thought of for buying yourself time and deferring costs in relation to design applications. So any questions on that before I hand over to Nicola to speak about trademarks?
I haven't seen any questions in the forum yet, Rob, but if anybody does have any that come up during Nicola's, or they have a thought, Rob's going to remain here and we'll be able to answer your questions at the end as well. Rob, I've got a question for you. What are the risks if you withdraw your design application?
That's a good one, Dom. So the biggest risk, of course, is that a third party has independently come up with that design and unbeknownst to you, or somehow somewhere your design has leaked out, and then they've gone and filed their own design application in that 4-month period. Now, I've been in the game for 32 years. And I can't recall that ever happening in relation to design applications. It does occasionally happen in relation to patent applications. Patents are obviously a much more hotly contested area. But in relation to design applications, I can't ever think of that happening. So I would put that down as a very low risk. Nevertheless, it is a risk.
Thank you very much, Rob. That's very interesting. Okay, we're just going to pass across to Nicola now, who will do her presentation on the trademark side of things.
Okay, thanks for that, Rob. Just before I go into detail, I just wanted to mention that although we're talking about these tips in the context of what's happening with COVID-19, a lot of these suggestions are good portfolio management in general. So, you know, we appreciate that everybody wants to be as cost effective as possible and not waste money on things that, you know, if they can save money, I guess we all like to save money. So whilst this is highly relevant to COVID-19, it's also relevant for once the pandemic is over and things return to the new normal, whatever that may be. So if we firstly talk about deferring acceptance of an application, I've listed the grounds of deferment there. I'll just run through them quickly and then I'll talk about them in a little bit more detail. So if you've had a prior mark raised as an objection to your application, you can defer the acceptance for as long as that cited mark is accepted or until it's withdrawn or lapses. If you've had a registered mark raised as an objection to your application and it's in the renewal grace period, which is a 6-month grace period, you can defer the acceptance of your application for as long as it stays in the grace period, or until it's renewed or it lapses. If you've filed an application to remove a mark for non-use, a mark that's been cited against your application, it will be deferred for the duration of the non-use removal proceedings. And that's really beneficial because sometimes removal proceedings can go on for quite some time, and you don't want to be in a situation where you need to request extensions of time of your acceptance deadline and incur costs for that. And then finally, if you've had a mark raised as an objection to your application and you try and overcome it by providing evidence of honest concurrent use, prior continuous use, or other circumstances, you can defer acceptance of your application for a period of 6 months. Now, what is other circumstances? Generally, other circumstances refers to something like a letter of consent. So the legislation gives you 6 months to negotiate with the owner of that prior mark to get consent. One thing to bear in mind with that ground of deferment is if you defer on this basis and you are unable to negotiate consent with the owner of the cited mark, and then you decide, well, I've actually got enough evidence of use, I'm going to prepare my evidence now, you cannot request deferment of acceptance using that ground again. You only get it once for a period of 6 months. On the other hand, it is possible to defer the acceptance of your application on more than one of these grounds. So let's say, for example, you've had 4 or 5 prior marks raised as an objection to your application. One of them is pending and one of them is in the renewal grace period. You can defer the acceptance based on the prior mark, the cited mark that's pending. When it's accepted or it's withdrawn or lapses, the deferment will terminate. And then if you've got another cited mark that's within the renewal grace period, you can request deferment again. So it's quite a good way of really extending the time that your application is pending, where at the moment, if you've got budgetary constraints and you don't want to allocate any expenditure to overcoming those objections, there's a number of ways that you can defer the acceptance. One of the things that I think it's always better to request deferment of acceptance sooner rather than later. And I mention this because in Australia, we get 15 months from the date of the objection to overcome it. And in my experience, applicants can be quite reluctant to defer because they're thinking, well, I've got 15 months, it's plenty of time, I can do it later if I want to. But the issue is actually people leave everything to the last minute, in my experience as well. And if you request deferment of acceptance shortly after the application has been examined, when that deferment ends, the amount of time that was remaining of the 15-month deadline when you request a deferment will be added on and a new acceptance deadline set. So if you had 12 months of the acceptance deadline when you requested deferment, you'll get another 12 months when deferment ends. Now, if you requested deferment, say 1 month before the initial acceptance deadline terminated, when your deferment of acceptance ends, you'll only have 1 month to get your application accepted. And you then, in the scenario where you might have to incur costs to request an extension of time. So I guess the takeaway is the sooner deferment is requested, the better. Oops, went too far. So what if you don't have any grounds to justify deferring the acceptance of your application? And this would be when, for example, you've only had the only objection that's been raised to your application is that the trademark is non-distinctive. You could file what's called a divisional application. So this is an application where you divide out the goods to which the objection relates. So if your non-distinctiveness objection relates to only some of the goods for which the application has been filed and not others, you divide those out into what is your divisional application, and your initial application, which we call the parent, will then go through to acceptance. It will be registered if there's no opposition, and at least you've now got part of your trademark registered. The benefit with a divisional application, and I guess this is also relevant at any time, is it allows you to maintain the priority date. The application will be re-examined, you'll get the same distinctiveness objection raised, and a new 15-month deadline will be set to overcome that objection. So whilst you will have to incur some costs in filing that divisional application. If you don't have a ground for deferment of acceptance available, the benefit is that in spending those costs, you are really restarting the acceptance deadline and buying further time that way. So if you're in an opposition with a third party, you can request a cooling off period. So what is a cooling off period? It suspends all of the deadlines in the opposition to allow for settlement negotiations. The initial cooling off period, you can request a 12-month cooling off period, or, but generally in my experience, parties are reluctant to agree to a 12-month period. I think it's far more common that people go, okay, well, we'll ask for 6 months initially, and if we can't settle it in that time, then we'll extend it by 6 months. The deadlines will be reset when the cooling off period ends. So let's say you've the notice of opposition has been filed, the intention to defend has been filed by the applicant, and you have your cooling off period that ends, then the new deadline will be set for the opponent to file its evidence in support of the opposition, and that's assuming the parties haven't been able to settle it. Both parties have to agree to the cooling off period, and either party can terminate at any time. So, you know, if the one party feels like the negotiations are not traveling quickly enough, then they can terminate the cooling off period. I have to date, in my experience, since this provision was introduced, I've never come across a cooling off period being terminated because the parties were too slow. So I guess the benefit of the cooling off period is, again, to buy that time, that you don't need to incur the cost of preparing evidence that can be significant, and certainly more than the cost of negotiating a settlement with the other side, with the other party. Just one thing I will mention, that if you've had a 6-month cooling off period and extended it by 12 months and the matter is still not settled, but the parties are actively in negotiation, you can then apply to the Trademarks Office to suspend the opposition. Again, both parties need to consent to the suspension. And the main difference with suspension is, with the cooling off, you can just request it without giving any reasons, and the request will be granted. Once you get into requesting suspension, the Trademarks Office likes to have some reasons justifying why further time is required, what progress the parties have made in settlement, how far down the track are they. And if you apply for multiple suspension of the opposition, so you have 6 months and then you apply again, the longer you take to settle, the more details the Trademarks Office is going to want to grant the suspension, because they want to see that you're not sitting around twiddling your thumbs. The parties are actually actively involved in negotiations. And if the parties are actively involved, you know, we've had cases where suspension has been granted for 2 or 3 or even 4 years. You know, sometimes the negotiations are complex and it just simply takes that long for the parties to reach an agreement. But as I say, as long as you're making progress, the Trademarks Office, and you can demonstrate that progress, the Trademarks Office will grant the suspension. Amalgamating or linking trademarks. These provisions came about because before 1 January 1996, trademark applications in Australia had to be filed in single classes. It wasn't possible to file one application that includes multiple classes. So now that the legislation allows for multi-class applications to be filed, there are a lot of old trademarks. So I'm talking about trademarks that were filed in maybe the 70s, the 80s, and the early 90s that are in single classes. It's possible to apply to amalgamate or link those into one multi-class registration. I would be surprised if there's still pending applications on the register that were pending and not accepted before 1 January 1996. But be that as it may, if there are any, the requirements for linking are an application for the same trademark was filed on the same day in a single class, and it was pending before 1 January 1996. So where this provision is more common is if you've got a trademark, if you've got multiple single class trademark registrations that you want to link into a single multi-class registration. And here the requirements are that it must be the same trademark that was registered before 1 January 1996. The goods or services were in different classes, the applications were lodged on the same day, and you have the same, they have the same registered owner. It's a fairly simple process. It's just a question of sending a letter to the trademarks office, setting out the numbers of the trademarks that you want linked. The trademarks office will amalgamate them and issue a new electronic registration certificate with a new number, but all of the priority details will be retained. So, you know, if the registrations were filed on 1 March 1988, that will the priority date will stay at that date. And there are no official fees required to apply to link a trademark. The benefits are reduced renewal costs, and I'll talk about that a little bit more in the next slide, because instead of having to renew, say, 5 single class trademarks, which each have a service fee and an official fee, you now only have 1 trademark in multiple classes. So whilst the official fee is still needs to be paid per class, the service charge, certainly in our case, it's just for a single, it's just a single service fee because it's 1 mark. Okay, there we go. So also now is a really good time to review your trademark portfolio. What should you be looking for? You should be looking for trademarks that are no longer in use and asking the question, well, if they're not in use, do we really have to incur the cost of renewing them? One point that I would just make here is if you've got a mark that has got an early filing date, you know, if it was filed in the 70s or the 80s, and it is something that was extensively used so that you have some residual reputation, you may want to renew it because you don't want to give up the early priority date. I guess the question here is maybe not to do a broad brush, take a broad brush approach, but still really assess what you want to do, assess each mark based on its merits. If it's purely for budgetary reasons that you need to save on costs, well, then if the mark's no longer in use, don't renew it. Really easy way of saving some money. The next thing to look for is, have you got any trademarks which are in use, but you're using them for different goods or services to those for which they are registered? And this is quite common that we find, you know, where trademarks evolve over time, and certainly in the fast-moving consumer goods area, you might have you know, something filed for meat products, and then it expands into snack foods, for argument's sake, which may be in a different class, and a new application was never filed to register it for those additional goods. And if you've identified some marks that don't need to be renewed, now all of a sudden you've got extra cash to file some new applications to cover marks that are being used but are not registered. One thing also to think about, instead of just filing a new application, is whether the mark, if it's a logo or it's got an image in it that's registered, is it still being used in that format? And whether it's, if the answer to that question is yes, is it possible to amend rather than having to file a new application? It's more cost effective to amend than to file a new application. The only thing with amendment is the Trademarks Office is very strict. The opportunity to amend is very narrow. So I think the legislation says, you know, as long as the mark does not have significant or substantial alterations that alter the nature and identity of the mark, you can amend it. So it really needs to be quite minor differences in the mark for it to be capable of being amended rather than a new application filed. And for us, it's really just a question of eyeballing the two marks, comparing the one against the other to make a determination of whether we think the changes are so insignificant that an amendment should be possible. So why do a portfolio review? The main thing is to save on costs. You avoid having marks registered that are not being used and are vulnerable to removal for non-use. So what happens is, you know, somebody files an application for a similar mark to yours or the same mark. They investigate, they see your mark's not in use, they file a non-use application, and then you will incur some costs there for dealing with that, whether, and especially if you've got an attorney that's advising you. And you can easily avoid that just by, you know, not renewing marks that are not in use, and even actively cancelling them if you want to, although that is quite unusual for that to happen. And also, you don't want to have marks that are not in use in your portfolio, because they really don't give you any benefit, because you can't sue you can't rely on that mark to sue a third party for infringement, because they could counterclaim to remove that for non-use. I think, okay, this is the last tip. Also, this is quite common, not only in times of a pandemic, but I think generally, the trademarks register should reflect the most up-to-date details of a trademark owner, and this includes addresses that should be updated if the company, the owner of the trademark, has changed its name, or if it sold the trademarks to a third party or acquired third party rights by assignment, or has it merged with another party. In all of these instances, ideally the register should be updated. There are no penalties in the Trademarks Act for failing to update. But one of the issues that you could have, for example, is, let's say you bought a trademark from a third party, it was assigned, there's a contract to say it was assigned, but you never updated the register. And then a third party applies to remove that trademark for non-use. The relevant section of the Act, section 92(4)(b), the wording is there, says that if the trademark has remained registered for a continuous period of 3 years or more, ending 1 month before the date on which the non-use application is filed, and at no time during that period the person who was then the registered owner had used the trademark, then it's vulnerable to removal for non-use. So the mark is in use, you've been using it, but the register reflects that the registered owner is the company that you bought the mark from. So it's a technical thing. You probably would be able to put on evidence to show, you know, that actually the mark has been used, but it's really a hassle that you don't need, and which could easily have been avoided by simply recording that assignment on the register to show that the ownership of the trademark has changed, and to reflect who the current and true owner of the trademark is. I think that's my last tip. Yeah. Any questions?
No, we haven't had any questions, Nicola, but I have one for you in terms of what's the latest kind of updates from IP Australia? I mean, are there any kind of updates in terms of is it business as usual there? Are there delays in their power at the moment, or is it pretty much business as usual?
I think it's business as usual. They are offering what they're calling a streamlined extension until the end of May, where you can request, essentially it's a free extension of time. So if you need an extension of the acceptance deadline, it's just a question of going on to e-services and ticking the box. So that is helpful for people who, you know, are having issues because of the pandemic at the moment. But no, other than that, I think it's business as usual. Everything's being examined and processed according to the normal timeframes. So yeah, I haven't seen anything untoward.
Okay, thank you very much, Nicola. And thank you again to Robert. Just a bit of housekeeping, just to let everybody know that we will be sharing the presentation and slides with everybody who's attended. And if you have any questions as well, you'll be able to send those through to either Nicola, Robert, or to your usual contact at Griffith Hack. And finally, there will be another seminar happening on the COVID series, the final in the series, coming up. So keep an eye out on your emails for that. So thank you, Nicola and Robert, and have a good day, everybody.